How do they bring? They should know first of all that there is a crime committed, there is a theft in our house, or there is a dowry death in our house. How the policeman will know? He should act on some information. Every police officer is empowered to gather some information. Suppose there is a theft in my house, I go to the police station. I tell the policeman, in my house, yesterday night, by about 10 o'clock, there was a theft when I was not at home. This we call as information. What is this? This is nothing but an information. This information is given first in point of time to the policeman. This is reported. This is called as first information report. Many of you have seen in newspapers that the FIR is registered. What is FIR? FIR is nothing but the earliest, that is the first in point of time, and information is provided to the police that is entered in the book. The book of investigation is concerned in the new code also, there is no much of difference. Same thing. So he does the investigation. We see in newspapers investigation has started, he is investigating, that man is investigating. What do we mean by investigation? In law, investigation means nothing but collection of evidence. That is all. Someone says that there is a theft in my house. Information will be received. The first thing that he has to do is to verify whether really any theft has happened. He has to collect evidence for that. Then he has to proceed further. Who has committed the theft? Who has committed the crime? He has to collect information. Now he comes to know that only X has committed that. So far as the X is concerned, how did he do the crime? What are the materials stolen by him? Or what are the other crimes committed by him? These are all the materials which are to be ascertained by the policeman by collecting evidence. He has been fully empowered to collect evidence in respect of the occurrence, in respect of the offences committed, in respect of the persons who have committed the offence, and in respect of the properties which have been subjected to the crime, etc. All these things have to be investigated thoroughly. That means he has to collect evidences. Already he has collected evidence. During that, what are our powers? We should know something, some very important thing. I have already informed you that whenever you come to know of any crime, it is your duty in law to go and inform the police that this has happened. Law experts, whether the policeman will respect you or not is a different story. But law expects us to go to the police station, to the nearest police station, and inform the policeman that this has happened. Law expects that policeman to register a case and collect evidence, that is do investigation. Until then, no matter is pending before the court. The FIR alone is sent to the court, and whatever is the evidence that is collected every day or immediately forwarded to the court concerned. Now finally, he has to conclude. Under the old code as well as the new code, he has to conclude. Yes, this crime is happened. Or he should conclude, no, it's a false complaint, no crime has happened. Now, ultimately, he has to give a report to the court concerned, having jurisdiction, he has to give a report. What is the report and what are the things which are filed along with that? I have told you, FIR, that is already there before the magistrate. Then he collects so many materials, so many evidences. They are submitted to the court. He examines so many persons who have witnessed or evidence. Those statements are sent to the court. And finally, his opinion is also reduced to the writing by way of report, and that is also filed. That we call as charge sheet. Right? That we call as charge sheet. Now, when charge sheet is filed before the court, the function of the criminal court starts. All these things, how investigation is to be done, how evidence is to be collected, how report is to be filed, who is the authorized officer to do that, all those things are defined, are well stated in the Code of Criminal Procedure and in other similar laws as well. In the procedural law it is stated. So he files a report. After that what happens? If once a report is so submitted, it is for the court to consider that report, to consider all the materials collected by the policeman and say yes, to satisfy itself, yes, investigation has been perfectly done, court should be satisfied. If the court finds that investigation has not been done properly and this man has acted with bias, or has omitted to do something, law directs the magistrate to issue further direction to the policeman. No, you are not done it properly. Don't do it further. Collect further materials. You are not done proper investigation. That power is with the court. Though the magistrate cannot interfere with the investigation, when a final report is filed, that is charge sheet is filed, he can direct the policeman to do further investigation. That is also repeated in the new code. So he will do further investigation. Procedural law is the Evidence Act. That old Evidence Act is now replaced by the new Act without much of changes except changing the section numbers. The Evidence Act is the law which regulates the proceedings of the court in the matter of trial, in the matter of appreciating the evidence. You may have a doubt. One court, the lower court says that he is guilty. When appeal is filed, the other court says no, he is not guilty. When the matter again comes up before the Supreme Court, this court says no, he is guilty. So three different views are taken. How does it happen? Can I say, without any basis, that so and so should be punished? Am I a monarch who can order for beheading a person? No, we cannot. Court is regulated by the Evidence Act. The Evidence Act tells the court, regulates the court, guides the court as to how he has to conduct the trial, that is, how he has to appreciate the evidence, how they receive the evidence on record, how he has to appreciate, and how he has to give a decision, a judgment on that. This is guided by the Evidence Act. That is also now changed. Name alone has been changed in the sections. Numbers have been changed. Substantively, there is no change made. See, this is the Evidence Act which helps the court, guides the court to appreciate the evidence. On appreciating the evidence at the end of the trial, the court gives a judgment. Now, appreciation differs from person to person. That is the reason why there are conflicting judgments which are coming up from courts. Because after all, judges are also human beings. Everyone has got his own way of appreciating, his own way of perception. I can say, what is the color of this jacket? This is a question. I say it is dark blue. How does I come to the conclusion? It is on appreciation, by application of my mind and my own perception. So on applying my mind, I perceive, that is my intelligence tells me that this is dark blue. Therefore, I give a finding, yes, it is dark blue. The same jacket is played for someone else before you. Your intelligence and my intelligence are not the same. Your intelligence may be something superior. Your perception, my perception are not the same. Your perception may differ. So applying your intelligence, applying your experience, applying your other inputs, you may say, no, this is black in color. You may say that also. You are also justified in saying that. What is the basic difference between these two? It is nothing but the difference in the matter of appreciation. Every man has got his own way of appreciation. But at the same time, if someone says, no, this is neither dark blue nor black, it is pure white, someone says that, would you accept? No, but the reason is it does not even appeal to our common sense. It will not appeal to the perception of a reasonable man. That is what the law says. The law expects the supposition of a common man. How a judge acts, how a judge gives judgment. He reduces himself to the position of a common man. Common man means a prudent man, a man with abundant prudence. And he, from out of various circumstances, various evidences, various materials, corrected. He supposes something. And that supposition we collected first. Then someone else apply your perception, you perceive something and you presume, you suppose. What is your supposition now? Yes, the husband already is killed. How do you say that? What are the inputs you have? Neighbors go, the husband rushes out, he opens the door and runs away. Wife is struggling for life inside. From these three circumstances, you perceive or you presume that the wife has been killed only by the husband. Right? This is the perception of a prudent man, a common man. Law acts only on the supposition of a common man, I tell you. Only on the supposition. Now, is it the only supposition? I tell you there is another supposition also from out of these circumstances. You ask the husband, why were you running when your wife was struggling for life? The husband says, just I came to my house, I opened the door, I found my wife lying, she was struggling. I rushed out to pick up an ambulance. He says that, this explanation he offers. Now what is your supposition now? What is your supposition now? Who committed that? Was the husband? No. This is the second supposition. When the explanation comes, your mind gives a different idea now. Your supposition changes. This is second supposition, right? Alright. This man doesn't give any explanation at all. I'm sorry, this man, he went away, he never returns. He never returns. What is your supposition now? Third supposition, he only killed. How do you come to that perception? How do you come to that conclusion? Because of his conduct. If really he had gone to pick up an ambulance, he would return within a reasonable time. He never returns. Which means his explanation is false. Therefore, from this additional information, you make eternal supposition, that is, he was the one who killed. The third supposition. There is another supposition, I tell you, another circumstance. The man went away, but there is another way, that is, back door is also there in the house. That is kept open. Right? So, some people who came from the other direction, they found someone else also rushing through the back door. He was running. Some unknown person. What is her position now? Husband runs this way, the other man runs through the back door. What is her position now? You can't have a different supposition now. You are in confusion now. He would have killed, or he would have killed, or both would have together killed now. What is the position? There is confusion. Now, that man is apprehended immediately. That man is found in possession of the Mangal Sutra of the woman. He is in possession. Now, what is the supposition now? He was the one who committed the murder. He was the one who killed. And what happens to the husband who also ran out? So, he would have either assisted or not assisted the other man to kill. Here we go with the motive. What should have been the motive for a husband to kill a wife or to run away like this? So, friends, I have now placed before you so many suppositions which you have arrived at, not me. As a legal person, you are all prudent people. Using your common sense and intelligence, you have told me that these are all the various suppositions from out of the same set of facts. Same set of facts. I place everything only before you. How the judge will give judgment? Whether he will act on the first supposition, second, third, fourth, how he will give judgment? The Evidence Act, the new act also guides him in such a way. How he has to act. There only it directs him that you please keep all the suppositions of proven men before you on your table. Right? You keep everything. Compare everything. You come to the conclusion, you take a decision. Out of these suppositions, which one is the most probable one? Is the most probable one. Now, from these suppositions, which is the most probable one? You please tell me now. Which is the most probable one?
Running with
Who is to be punished? Put it simply. Who is to be punished? Two persons are there who are prosecuted. Who is to be punished now?
the one who ran with Mangal Sutra.
I have said these are the evidences.
Mangal Sutra, the one who ran.
These are the evidences. So that you will now understand that how difficult it is the job of a judge. There are two judges here, division bench. They are deciding judgment now. Okay. So this is the difficulty for judges. As a judge, what I would have done in this case is, I would have punished both. Because the other man has got no business to enter the house. These are the aggravating circumstances. That man, the third party, has got no business to enter the house through the back door. What part did he enter? At that crucial moment, then soon after, he is found in possession of the Mangal Sutra. How did it come to his hands? He has got no explanation. Therefore, it is very certain that he is involved in the crime. Though nobody has seen him strangulating or doing some harm to her, from out of these suppositions, this is the most probable supposition that he was the one who is also involved in the crime. Then what about the husband? The husband will also will not be punished because of his conduct. If really he is innocent, what he would have done? He would have chased that man. That man escapes with a Mangal Sutra wife. What would have been his conduct? He would have chased him to catch him hold. He did not do that. He finds a different way to escape. This is one thing. This is one thing. Secondly, something happens to the wife. What will be his conduct? He will cry for help, at least. Oh, please come, my wife is killed. Somebody is stabbing. Come, like that. He will cry. That will be the natural attitude of any human being. He doesn't do that also. Instead of that, he tries to run away from that place. When I told this example, at the outset I told you, who cried for help? The wife cried for help. Wife cried, oh, I am stabbed, like that. This man did not even open his mouth. He was inside the house. From these things, the most probable supposition is that these two fellows have jointly killed her and they tried to escape through different ways. Therefore, both are to be punished. Where do we get all these things? This is also by the guidance we find in the Evidence Act. The very important provision in the Evidence Act is presumption. You go by presumption. The presumption is based on the natural human conduct. In all these suppositions, using your common sense, you went by the natural human conduct only.